3655 and 36 let me repeat those again. 26-3655 FH and 3656 FH. Appearances, please.
Thank you, Your Honor. David Denhoughton on behalf of the people.
Robert Champion appearing on behalf of defendants, Your Honor.
All right, thank you. Hold on, and West, I think the person you might be looking for is probably waiting for you outside. Yep, thank you. All right, Mr. Westrup is also here. He is currently in pretrial custody. We are here today for a final pretrial conference. This is one of the cases currently set for trial, I believe, to begin on April 21st. Do we have a pretrial agreement or resolution?
We do, Your Honor. I believe I left it in the conference room here.
No problem. I can do it. Well, because I don't have that. Mr. Denhoughton, why don't you go and tell me what the plea is?
Yes, Your Honor. It's my understanding that Mr. Westrup will be accepting the people's plea offer, which is to plead guilty to count 1, possession with intent to deliver methamphetamine as a habitual second offender notice. In exchange, the remaining counts and enhancements on that particular file would be dismissed. This plea is in file 263656. Also, as part of this plea agreement, case number 263655 will be dismissed in its entirety at the time of sentencing.
Mr.
Statement of the plea agreement, Your Honor.
All right, thank you very much. Mr. Westrup, is that how you wish to resolve today's files?
Yes, sir, Your Honor.
To the best you can. You may remain seated if it's more comfortable. Raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
You may lower your hand, Mr. Westrup. All right, Mr. Westrup, we've got 2 cases here. We're going to go over them both. The first case has an alleged date of August 10th of 2025. I don't need to ask you much about that one yet, but I'm going to look at the second date. The second date for the second file has an alleged event date of December 17th of 2025. At that time, were you on probation or parole?
Yes, sir, Your Honor.
And which one?
I was on probation.
And has there been a probation violation taken against you?
Yes, sir.
Was it in front of me? No? Where was it? I don't remember.
It was in front of you.
Yeah.
It was taken care of over video conference. I was in the jail.
All right, but that's already, have we issued a sentence already?
Yes,
Have
sir.
I?
175 days.
All right, thank you very much. Make sure I remember that, Mr. Champion, when it comes time for sentencing, if he was on probation. I'm sorry, in confinement. All right. So, were you on, here's the key question, were you on bond at that time?
No, sir.
All right, good, thanks. The reason for that is important because if you were on parole, any sentence for any plea would run consecutive to that parole sentence, which means you'd have to finish the parole before you could serve this sentence, but that doesn't apply. The other one is if you were on bond for a felony at the time this offense occurred, if you were convicted on that other felony, they would run or could run consecutive as well, but that doesn't apply either. So those are 2 good things. So before we go over this pretrial agreement, there's a form sometimes we get, but Mr. Kim doesn't have it, but I can go over it.
Could I step out for just a moment, Your Honor?
Yeah, sure.
Thank you.
I'm gonna wait. I'm not gonna do any more talking until he returns. Let's just recess in place. All right, we're back on the record for People versus Westrup. All parties present in the court recess, including Mr. Champion, are present. Thank you. All right, so what Mr. Champion is doing is handing me now a copy, or handing me that written pretrial agreement. And first, I can say that it is consistent with what has been told to me today on the record. Mr. Westrup, I did see you sign it here when Mr. Champion brought it in, which is okay, but I just need to make sure. Did you go over the terms of this written agreement before? All right, now, did Mr. Champion provide you advice, talk to you about all your options, talk to you about the evidence?
Yes, sir.
All right, and has he talked to you about the terms of this agreement?
Yes, sir, Your Honor.
And are you satisfied with his advice?
Yes, sir.
Again, while it may not be the greatest thing to do on a Monday morning here in Missaukee County, do you feel that entering this plea is in your best interest, considering all the other files and cases and
Yes,
evidence?
sir, Your Honor.
All right. Now, I say that I don't really know what all the evidence is because there's no, I don't have a police report, so I don't know anything. All right. So that signature that's on page 2, that is your signature?
Yes, sir.
All right, good. Thank you. Now, let's go over the terms of that agreement a little bit better. There are 2 files. The first file is file 26-3655FH. And in that file, it's alleged that on or about August 10th of 2025, you had received and concealed stolen property that had a value of $1,000 or more, but less than $20,000. Now, that itself is a felony punishable by up to 5 years and or up to $10,000 or 3 times the value of the property, whichever is greater. Now, there's also a third habitual felony offender enhancement that could have increased that maximum punishment from up to 5 years to up to 10 years, and from up to 20,000 or 10,000 up to 20,000, or again, 3 times the value of the property. That count is going to be dismissed. Now we turn to the second file. This file is 26-3656FH. This one alleges events that occurred on or about December 17th of 2025 in Riverside Township in Missaukee County. And on it, you're charged with 2 counts. I take that back, 3 counts. Count 1 is possession with intent to deliver the controlled substance, methamphetamine. That's a felony punishable by up to 20 years and or up to $25,000. Now, there are 2 potential sentencing enhancements that are at application here. One of them is a second or subsequent drug offender enhancement. Now, that can increase the maximum punishment He's pleading guilty to the PWID. Oh, it's as a HAB second.
As a HAB second.
I'm sorry. Thank you. I was confused. That is again punishable by 20 years and or $25,000. Now, there is a 4th habitual felony offender enhancement that could increase that maximum punishment from up to 20 years to up to life. However, I'm told that the prosecutor agrees that you'll be able to plead as a second habitual felony offender. Now, that means that the maximum punishment can be increased within the discretion of the court at the time of sentence from up to 20 years to up to 30 years. Count 2 is possession of the controlled substance methamphetamine, which apparently is a separate act, or maybe it's ecstasy. That's listed there as well. Either way, it's a felony punishable by up to 10 years and or up to $15,000. Plus, you could be sentenced as a second or subsequent drug offender within the discretion of the court. That could increase that maximum punishment from up to 10 years to up to 20, and from up to $15,000 up to $30,000. Or in the alternative, you could be sentenced as a 4th habitual felony offender. That could increase that maximum punishment from up to 10 years to up to life. However, count 2 and its enhancements will be dismissed. Count 3 is a charge of maintaining a drug house. That is a felony or high court misdemeanor punishable by up to 2 years and or up to $25,000. In addition, there is a fourth habitual felony offender that could increase it up to 15 years, but it doesn't matter because count 3 is going to be dismissed. And count 4. Count 4 is a charge of being a felon in possession of ammunition which is a felony punishable by up to 5 years and or up to $5,000 plus mandatory forfeiture of the weapon or device. Additionally, as you were charged as a fourth habitual felony offender, that could be increased from a maximum punishment of up to 5 to up to life. However, that count will be dismissed. Do you need me to repeat any of that at all for you, Mr. Westrup?
No, sir, Your Honor.
All right, good. Now, by entering a plea of guilty to that one count, if I accept that plea, you're not going to have a trial of any kind. Does that make sense?
Yes, sir, Your Honor.
Now, I have here another form handed to me by your attorney, and at the top it says advice of rights. And it lists the rights that you're going to be waiving if you enter a plea of guilty. Is that your signature?
Yes, sir, Your Honor.
Did you read through this before you signed?
Yes, sir.
Did you understand the words that you read on this page?
Yes, sir, Your Honor.
And even more important, you understand that if you plead guilty and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
Yes, sir.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. So, other than the terms of this agreement that we talked about, have there been any other threats and duress, coercion, pressure to get you to plead guilty?
No, sir, Your Honor.
All right, so therefore you enter the plea of your own free choice.
Yes, sir.
Now, regarding sentencing, I trust that Mr. Champion has talked to you about potential sentencing. Is that correct?
Yes, sir.
Now, on this plea agreement, I know that he did because at the bottom, it shows that there's an estimated guideline range. Now, Michigan has what's called the Michigan Sentencing Guidelines, and they help the court establish what the legislature thinks might be a reasonable proportionate sentence. The guidelines are not mandatory. While the courts must use them, the court doesn't have to follow them, but they're a very important tool. On here, it says the guideline range might score 51 to 106 months. Do you understand that that's just an estimate? It's just a recommendation.
Yes, sir.
Has anyone made any promises to you as to exactly what I will do at sentencing?
No, sir.
All right. I'm about ready to take your plea, and I'd just like to check one more time. Is there anything else you think I need to know, or that I haven't answered for you, or that I need to explain better for you?
No, sir, Your Honor.
All right, good. All right, as to count 1, possession with intent to deliver, or possession with intent to deliver methamphetamine. How do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what it is that you did that makes you guilty of offense. Again, turning your attention back to December 17th of 2025 over in Riverside Township here in Missaukee County. Looks like you had a run-in with a couple sheriff deputies, and looks like even Mr. Blazak, who was probably your probation officer. What happened on that date?
They came over for a compliancy check, and I mean, everything went well. I was pretty cooperative. Failed a drug test, got my violations, and they found me. I had methamphetamine in my home.
Tell me about that. How much methamphetamine?
Roughly 33 grams.
All right, so over an ounce.
Yes.
Yep. And how was it contained or packaged, or
It was in a bag.
just one single bag?
Yeah, one single bag with 33 grams, and I had empty, brand new bags throughout the house.
Okay, so you had like small jeweler bags that you would then put it into to distribute?
Yeah.
And that was what your intent was when you possessed that 33 grams or so and all the extra baggies?
Yes.
Okay, all right. Did you have things like scales as well?
Yes, sir. I had a 6 scales.
All right. All right, and you knew that that substance actually was methamphetamine?
Yes, sir.
And in your mind, did you have any lawful right to possess that?
No, sir.
Okay. Also, Mr. Westdorf, let's take a look here. Do you admit that on or about January 1st of 2024, you were convicted in this court for that's a use. Was that a second or subsequent? hold on. I've got choices here. We'll just go with the first one. Sir, do you agree, Mr. Westrup, do you agree that on March 3rd of 2023, you were convicted, looks like in the 13th court up in Traverse City or Grand Traverse County, possession of the controlled substance, cocaine or heroin less than 25 grams?
Yes, sir.
All right, thank you. Mr. Denham, do you believe that the defendant provided a factual basis for both the plea as to count 1 as well as the second enhancement?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court's compliance to 6.302?
Yes, sir. I did just for clarification, as a habit, the court, I think, said second
Oh,
subject.
I'm sorry, as a half second.
Yes.
Thank you very much. Mr. Champion, do you agree with all that?
I do, Your Honor.
All right, thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony given by the defendant under oath satisfies the required elements for proof for count 1. The court further finds that the defendant has stated enough evidence to establish the second habitual felony offender enhancement. Therefore, the defendant is found guilty of count 1 as a second habitual felony offender, counts 1, 2, and 3, and any other enhancements, as well as the charge and enhancements in file 3655 will be dismissed in the time of sentencing. Mr. Westrup, we should be back here at sentencing in about 4 to 5 weeks. Between now and then, as you probably recall, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report that will describe to the court the terms of the pretrial agreement, the facts behind the case, any statements, information you make will provide information about prior criminal history, performances on bond and parole and probation, and it will also include a score of the guidelines, which again are not mandatory, and it will make a recommendation as the sentence. Find that it's merely a recommendation. You're going to get a packet. You're going to complete that packet, turn it back into their office. You'll be subject to an interview. You have the right to have Mr. Mr. Champion present during the time of the interview. And once that's prepared, Mr. Champ is going to come back and go over it with you. Each side has the right to come back to this court and make objections, request corrections, whether it's to the scoring or the content. You understand, sir?
Yes, sir.
Mr. Westrup, do you have any questions about what we have done today?
No, sir.
All right. Mr. Champion, anything further?
No, Your Honor. Thank you.
The court revokes bond, remands the defendant to the custody of the Missaukee County Jail. Anything further, Mr. Denham?
No, Your Honor. Thank you.
Thank you. We'll see you in about a month, Mr. Westrup. We are adjourned.